This is Richard Harding speaking. By 1975, when the LRC was established, I already had a reputation and a track record as somebody who was very concerned about the inadequacy of complaints against the police systems throughout Australia. The Attorney General did not appoint me as a commissioner, but he appointed me as a consultant to the Commission. This meant that I was working with the established commissioners, most notably with Michael Kirby, Gareth Evans, Gordon Hawkins and Jerry Brennan. As the second reference was to be on the closely related issue of criminal investigation powers, I was also to be involved in this. The process itself was a remarkable one. I don't recall whether the Commission at that time had proper offices in Sydney, but I do recall that almost all of our meetings occurred at weekends in University House at ANU. I would fly in from Perth on a Friday and spend the next 2 days at University House before flying back on the Sunday evening. Michael and Gordon came down from Sydney, Gareth from Melbourne, and Jerry at that time was based in Brisbane. Typically we would start work very early on the Saturday morning in a small conference room, and Michael would keep us going along at a rollicking pace for most of the day. We were allowed a brief break for a simple lunch, no booze, much to the discomfiture of Hawkins and myself. And by about 5 o'clock, Michael was recognising that some of us needed some proper sustenance. His idea was that after some food we would resume until 10 o'clock at night or thereabouts. This always bemused Hawkins, for whom the purpose of a working day was to relax with a glass or two of beer after it, and occasionally he and I actually skived off after Michael allowed us a break and went down to Canberra and found one of their very few drinking outlets for a relaxing beer or two. The pace of work was actually horrendous, and as Michael has often noted, Gareth was extraordinary in his capacity for work, particularly in the criminal investigation reference for which he took the lead. I recall the occasion, despite Michael's alarming work ethic, as being one of great camaraderie and fun. We actually really enjoyed tackling the hard issues and trying to find a way through them. There were moments of high comedy also. We had agreed in relation to the criminal investigation reference that there should be a period after which the police, having arrested somebody, had to notify a magistrate and get an extension of the period during which that person could be held for questioning. To agree this would have been a great breakthrough, because of course there were no such provisions at that time in Australian federal law, ACT law, and most jurisdictions. Gareth was of the view that this period should be as short as possible, and he suggested 4 hours. For some reason, the rest of us seem to think 6 hours was a bit more realistic in terms of the logistics from the point of view of police processes and contacting a GAP or a magistrate or whatever. But Gareth was determined to get his way, and one late afternoon he made quite a long speech, one might even call it a peroration, about why 6 hours was wrong and 4 hours was right. It was the sort of monologue for which he later became famous in his political life. Learned, erudite, persuasive, but too much of it. Hawkins was beginning to raise his eyebrows and smile, and the rest of us were beginning to lose our attention span. Eventually, Gareth wound down. Michael, as chair, let silence move through the room just for the right period of time, and then said, "Tell me, Evans, are you an only child?" This may not have, strictly speaking, addressed the substance of the issue, but it seemed to settle the argument to the great amusement of everyone else around the table. I should add that Evans took all this with great grace in the end and continued to work at a fantastic speed on the project. Both reports made a great impact in terms of public debate and ultimately in terms of statutory change, and it was certainly a privilege and a lot of fun to have been associated with these things. With those two references, my role as a consultant ceased, but I became a part-time member of the Commission in the mid-1980s. I got involved in 4 or 5 projects. As with references 1 and 2, the calibre of the people involved was always very high. In terms of Aboriginal customary laws, I had not worked with Bruce DeBell, but James Crawford had taken over by the time I was a member, and his work was astonishing in terms of his grasp of issues which I'm sure were quite unfamiliar to him at the outset, but showed great skill and empathy in getting across them and producing what has become an exemplary, very frequently cited report on this very difficult subject. Robert Hayes led the Spent Convictions report and was excellent, as was Tim Smith with the evidence report. And then George Zendowski was in charge of the Commonwealth Prisoners Act and the sentencing references, and again in a quite different way from the kind of frantic manner in which Evans had previously worked, or the calm and rounded manner in which Crawford worked. He also was absolutely across these subjects in a very detailed way. So my experience, and in none of these was I a prime mover, I don't want to pretend that I was, in my experience the calibre of the work in the times that I was involved was very high. I certainly contributed directly to this in references 1 and 2 and was more peripheral, keeping, if you like, a watching brief from the point of view of the Institute of Criminology in these other references. But it was a privilege to have worked with the Commission and with such